Hello and welcome to episode 40 of Not Reserving Judgment, a podcast about the latest intrigues, outrages, and triumphs in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCF's litigation director.
Sorry. My lights are just flashing. I just have to adjust them, and we'll just start over if you don't mind, because it did it twice. Hello and welcome to episode 40 of Not Reserving Judgment, a podcast about the latest intrigues, outrages, and triumphs in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCF's litigation director.
And I'm Joanna Baron, executive director of the CCF.
In today's episode, I'm going to talk about Saskatchewan's challenge to a Good Samaritan law that is supposed to encourage people to call the help when they see someone overdosing on drugs.
I'll tell you about an Ontario court's decision this week that found that the legislature was indeed permitted to silence Member of Provincial Parliament Sarah Jama from speaking in Queen's Park after she supported the October 7th attack.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to update you on the anti-Israel encampment situation, because even though we've talked a lot about this already, there are some really interesting legal developments this week. So as listeners know, these anti-Israel encampments have sprouted up across North America, and they've been, depending on your viewpoint, either peaceful protests aimed at seeking divestment from Israeli firms complicit in genocide, or gatherings of mostly spoiled brats who hate their parents so much that they're willing to openly support one of the most evil terrorist groups on earth. Regardless of your viewpoint, there's a debate about whether these encampments are protected expression, and we've discussed at length why we have some doubts about that. Briefly, it's not clear that these encampments are a form of expression that's protected, and university campuses might not be places where the charter applies. Last week, we told you about McGill University's failed attempt to get rid of their encampment, but this week I want to focus on the University of Toronto. Just before I get into the U of T stuff, though, a couple small updates about other encampments. So at least two of them at McMaster University in Hamilton, Ontario, and at Queen's in Kingston, Ontario, have now packed up and ended. And I'm guessing a lot of these students either had summer jobs they needed to go to, or maybe they had leases ending, or they just wanted to get out of Kingston. Completely understandable. Whatever the reason, those encampments are now over. Also at UQAM in Montreal, a partial injunction was granted where the judge said that the occupiers had to stop blocking UQAM's security cameras and also provide a 2-meter path so that people can get through and access buildings. And the UQAM case is pretty interesting because it's a school that, unlike McGill, receives almost entirely government funding. And so it's a place where the charter is a bit more likely to apply. But let's not get too deeply into that, because I do want to focus on U of T. So basically, people have asked me, they keep asking me, does the University of Toronto need the court's permission to expel protesters from their private property like the university campus? And I don't think that they do, but it's possible that the police here have told U of T that they won't move in without an injunction, without a court order. It's also possible that U of T really just did opt for the losing strategy of appeasement and negotiations, which caused the encampment to grow to now 177 tents, surrounded by a fence that the university itself put out and that the occupiers are now using to keep out people whose views don't align with Hamas. U of T went so far just a few days ago, in fact, as offering not to discipline any professor or student who complies with their demands to leave this occupation, except for those who engaged in hate speech. And I think this is inappropriate, considering that there were so many obvious breaches of the student code of conduct, and rewarding bad behavior tends to lead to more of it. But anyway, U of T has finally had enough, and they've decided to seek a court order that would require the occupiers to take down their tents, not put them back up, stop impeding other people, and only gather on campus between or not gather on campus between 11 p.m. and 7 a.m. In other words, they can still go and protest all day, every day. They just can't stay in camp overnight. So one thing U of T needs to show in order to get the injunction, and just a reminder, an injunction is a court order pending a full hearing on the merits, is that U of T will otherwise suffer irreparable harm. And usually that's harm that can't be compensated later on in money damages. And for this, the university's notice of application seeking this injunction seemed a little bit odd to me. Mainly, the harm that they cite is to their reputation, and more specifically to their brand, which is called inclusive excellence. And this is quoting from their application. They say, the university's inability to control the violence, harassment, harmful and discriminatory speech, and property damage have undermined the university's reputation as a free and open atmosphere for respectful discussion and debate, and as a safe place for higher education. To back up this reputational harm, they note that, quote, community members have reported seeing deeply disturbing language such as Zionists go back to Europe, glory to the martyrs, and burn Tel Aviv down. They add, similarly, community members have reported being swarmed, assaulted, or harassed because of their views, their heritage, or other personal characteristics. And again, they say this causes reputational harm. They also cite thousands of letters from parents, donors, faculty, etc., who are opposed to the encampment. But they also admit that there's a lot of letters in favor of the encampment. And finally, they note what I think is the more convincing argument, which is that the university needs an injunction because it hasn't been able to access its own property for things like celebrations, activities, and, quote, open and free dialogue, which includes their upcoming convocations in June. And almost as an aside, at the end, they point out that this violates the Trespass to Property Act, which I think, if true, probably should end the story. But anyway, to win the injunction, they also have to show that the balance of convenience is in their favor, which is to say that they're more inconvenienced if the injunction isn't granted, then the other side will be inconvenienced if it is. And then they get into talking all about whose expression would be more affected, the protesters forced to vacate or the people who currently can't access that space for expression. And I think that's a little bit of an odd choice, considering they're making it all about speech when I think this is more of a trespass case. But they do tack on right at the very end the words, quote, the commission of torts, i.e. trespass, is not a protected form of expression. And, maybe this is some sort of strategy, and I guess we'll learn at the hearing whether or not they're going to really focus mostly on expression or whether they'll get more into the trespass stuff. I really don't know. And speaking of hearings, there was a case conference yesterday, and I wasn't there, but I read on Twitter that it got off to a really slow start because apparently everyone and their uncle decided they want to intervene. This includes the CCLA, the Canadian Association of University Teachers, Independent Jewish Voices Canada, which is an anti-Israel group, OPSU, Amnesty International, B'nai B'rith, National Coalition of Canadian Muslims, etc., etc. And so that's what took up most of the case conference. And U of T wants this heard as early as Friday. The protesters obviously want it heard as late as possible. And so we don't actually know when this injunction motion is going to go down, but I hope to go watch it in person if I have time. And if not, I will definitely be reading all about it. Joanna, you were at McGill this week, so you actually saw one of the encampments. What was the vibe like there? What's going on?
So as you may know, they have, I don't know if they're doing this at all the encampments. I think they are. They have like a fenced off perimeter. So I did not attempt to cross through the fences. To be honest, it seemed like you could like smell it from 100 miles away. And I just, didn't want to get involved. But from what I heard, because I was teaching a class yesterday, I'm here teaching for the Montreal Economic Institute's Liberty and Leadership Seminar. And so it's a lot of college students and a few recent grads. And I was speaking about free speech. So at the end, I just kind of like, fed some chum to them. And it was like a free for all vent session. Got pretty intense. There was one young woman who came up to me afterwards and had like the pendant that looks like the state of Israel, although I'm sure she wouldn't call it that. And she told me that she has family in the West Bank. she, she was making the case that because these universities get public funding, they should be considered public spaces. But anyways, most of the students were like, I got harassed and I wasn't able to go to class. But what I was going to say is, so apparently the McGill encampment is pretty dead now, and it's mostly not students that are there. It's mostly just professional protesters. But apparently UBC and U of T are still pretty hopping. I don't know if either of you have been by the U of T encampment, but apparently there's a lot of people there. And one of the students asked me a thoughtful question, which I had no idea how to answer at the end of my talk. He said, actually, and I didn't know this, all of the student unions are robustly funding the encampments. Like, I'm not surprised to hear this, but I wasn't. And he was like, what's the limit of student unions? Like, how far can they go in just like using all of the student union dues that they get just to fund people to like buy tents and, I don't know, buy little camping burners and stuff like that. And I really, obviously, that's like so far out of my zone of awareness, but of expertise. But anyways, like the other thing that I saw that made me kind of feel bad is a bunch of, like, right now is convocation days at McGill. People are graduating, and because they can't convocate on campus because of this eyesore of an encampment, that it's just like a hygiene risk and just like taking up the whole part of lower campus, they're having to do their convocation at the Bell Center. But because everybody wants like nice pictures on the picturesque campus, everybody's coming and taking pictures with like their flowers and their parents. And like, I saw a lot of these students and I feel so bad. I saw like one or two take a picture with the encampment, which was kind of funny. But you just have to think, this is the class of 2020, right? That matriculated in 2020. And it's just so shitty for them that they have to like walk along this encampment with these menacing looking professional protesters to take their mom and dad pictures. I don't know, it's a mess. What a state of affairs. And the McGill president keeps writing thoughtful and compassionate op-eds explaining how he supports the right to protest, but that permanently encamping on a private property on campus is not encompassed in that. But they seem to be pretty dug in, so we'll see what happens. What do you think, Christine?
I still maintain that this is, by mid-June, this is all going to be gone. Like, once the protests are not bothering people on campus, I do think that they're going to leave. Like, maybe there will be.
I don't think so. I honestly don't think so.
Yeah, I mean, like, we don't.
Me and you, CBG, will have a bet. Like, these people don't have better things to do.
Yeah, I think that there's maybe going to be a group of people who stick it out, but for the most part, it's going to come down. And when it's only like a really small group of the professional protesters and the campus is otherwise empty. And look, even these are campuses that are urban campuses, so it's a little bit different from those other universities that you said that seem to have cleared out already, like Queens. But even U of T, King's College Circle, which is where this protest is, in the middle of campus, that's just surrounded by university buildings that are absolutely dead during the summer. And if there's only a few hardcore professional protesters left in July and mid-June, I just think that it will be easier to have them removed. Like, no one's going to be even seeing them, since that's in the middle of campus where no one otherwise goes. It's not like surrounded by office buildings. So I don't know. Yeah, let's have a bet on it. We'll bet like a cup of coffee.
Yeah,
or
I think the McGill
minor.
encampment, because it's like right, like, it's like a tableau in the middle of downtown Montreal. Like, I think
that one's more
very
obvious. The
September.
U of T one, I think, is
Yeah,
the
it's
one
more
that
hidden.
It is, and I think their convocation. So convocation is happening right now at McGill. I think it's supposed to be next week at University of Toronto, if I'm not mistaken. So I think that's why the University of Toronto one is like still, going hard.
Well, there's
because
just
they're
a whole
still bothering
psychology
people.
to these people that they just like can't let it go. And there are people, and I know some of them personally, who have made this their whole personal identity post October 7th, just like the fight for a free Palestine. Like, it's their whole raison d'etre. And I think because of that, like, these people are just completely dug in. And until they get the universities to capitulate to their demands, whatever those demands are, which they won't, right? Like U of T has made certain offers. I just think this is like a form of psychosis, mass psychosis.
I mean, one of the things that you commented on when you were, walking by campus yesterday, you sent us some pictures, and it's not just about
No.
the war in Gaza. It's kind of like an amalgamation of various left-wing causes.
Yeah, there was people who hung up just like random red dresses from trees, which I guess is a symbol of missing and murder Indigenous women. There's signs for George Floyd. There's stuff about pink washing and trans rights. Like it's the unicause.
Yeah. So
It always is.
I do think that people make that their personality, like
Yeah.
various protest causes. It becomes like who you are. Anyway, let's move on. I'm going to move to my news headline. We've sometimes received feedback on this podcast that we don't have enough prairie focused or West Coast focused content. So this one's for you, critics. So I'm going to be talking about a case coming out of Saskatchewan that's headed to the Supreme Court called R and Wilson. And it's about what's called a Good Samaritan law, the federal Good Samaritan Drug Overdose Act. And this is a federal piece of legislation that provides some legal protections for people who experience or witness a drug overdose. So if someone witnesses an overdose and they call 911, the Good Samaritan law can protect people at the scene of an overdose from criminal charges of simple drug possession and breach of drug possession conditions on probation or parole. Now, obviously, those things are illegal. Ordinarily, you could be subject to arrest and criminal charge. It is a criminal offense to have possession of things like heroin and fentanyl. And the Good Samaritan law doesn't mean that those things aren't criminal. It just means that you cannot be charged and convicted of minor possession or simple possession if you are at the scene of an overdose that's been called in. So this protection is important because, the policy rationale is that it is often other drug users who witness an overdose, and if they are vulnerable to being criminally charged, if they call in an overdose, they are less likely to call in an overdose and people will die. So the law actually applies to the people who call in the overdose, to people at the scene, and also to the person who is experiencing the overdose. But it doesn't provide unlimited protection from arrest. So it doesn't give legal protection for people at the scene of an overdose who have committed more serious offenses, like if there's an outstanding warrant for their arrest, if they are involved in production or trafficking of drugs or other more serious crimes. So, and it's this kind of carve out that is going to be considered by the Supreme Court in this case, R and Wilson. So in Wilson's case, he was driving in a truck with 3 other people, and a woman who he was driving with had taken fentanyl, and she became unconscious and began overdosing. And the overdose was called in. They called 911. The ambulance, the EMS, was the first people on the scene, and the police then arrived. And when the police arrived, they saw drugs at the scene, as one might expect when there is a drug overdose. And so they actually arrested all 4 people. They arrested Wilson, and they arrested the person who was overdosing, and they arrested the other 2 people. And then it was incident to that arrest. So they arrested them because they saw the drugs. It was then following their arrest, they searched them and they searched the vehicle. And that's called a search incident to arrest. And police search people when they arrest them just to make sure, they don't have weapons. They're not going to do other bad things. They don't have evidence of other crimes. And they did find evidence of more drugs. They also found drug paraphernalia that was indicative of trafficking, and they also found guns. So Wilson was then arrested again and charged with these weapons offenses, and he was actually convicted of the weapons offenses. And it's the weapons offense that is going he was convicted. It was struck down by the Court of Appeal. And then the question of, was that first arrest prohibited by the Good Samaritan law, is going to be considered by the Supreme Court. So I have a few things to say about it on a whole bunch of different aspects of this whole issue. So the first thing is this policy rationale of the Good Samaritan law in general. So police have said that the Good Samaritan law, they credit it, some police forces have credited it for an increase in 911 calls for overdoses. I have not actually seen data on this. Drug addicted or drug using populations are kind of notoriously difficult to study. It's very difficult to ask drug users, how do you feel about calling 911? Drug users tend to have a negative relationship with police and a relationship of distrust with police. So it's difficult to get at whether or not if there has been an increase in reports of overdoses, yes, but it's hard to actually make the link between that increase and the Good Samaritan law. If I were to speculate, I would say it's more likely that there are just more overdoses because the rate of drug use went up during the pandemic, and the level of toxicity of drugs also seemed to increase with the explosion of fentanyl as a street drug. So it's really difficult to actually understand if this has resulted in the policy outcome that we are hoping for. But certainly, I'm not objecting to the concept of the law. I think that people in drug subcultures and people who are addicted to drugs, they do have a negative relationship with police, and I think might be quite afraid to take advantage of even the protection afforded by the Good Samaritan law. We want people to be able to call the police to save someone's life without the fear of being arrested. Now, I've done a show on this, my television program, Canadian Justice. I interviewed a criminal defense lawyer named Kabir Sharma about this law. And about, how this law is used in practice, how Good Samaritan laws are used in practice. And he actually said it almost never comes up in criminal defense work. And that might seem surprising to us, but he says what he thinks is happening is that police just basically exercise their discretion not to arrest or charge people of simple possession when they are at the scene of an overdose. Like it is up to the discretion of the police if they want to lay those charges. And when someone's overdosing on drugs, he says they often just don't lay the charge when it's been called in. So what the government is arguing. So I explained what happened in the case. All four of these people were arrested. The police found drugs when they did the search incident to arrest. They found the drug paraphernalia. They found the weapons. Wilson was arrested, convicted at trial of the firearms offense. And it's this acquittal, the Court of Appeals acquittal of Wilson that's going to be considered now. And what the government is arguing is kind of interesting. So the Good Samaritan law says you cannot be charged and convicted of simple possession, but it doesn't say anything about you cannot be arrested of simple possession. It just says you cannot be charged. And if other evidence is found incidental to the arrest, the government of Saskatchewan says they can lay charges related to that other evidence, which they found in Wilson's case. Now, on a purely technical point of view, I mean, that is what the law says. The law says you cannot charge and you cannot convict. It does not say you cannot arrest. But what the Court of Appeal found was that there was no purpose to the arrest for simple possession other than charging. And when the purpose of the arrest and the charge are so intertwined, there isn't a meaningful difference. It's not like they were arresting Wilson for something he did that was not subject to this sort of limited immunity. If they had showed up and Wilson was aggressive with police or threatening them in some way, or if he had an outstanding warrant, then they could arrest and charge him with that. But they arrested him here on the pretext of simple possession alone. They didn't have another reason for that arrest. And the Good Samaritan law wouldn't protect him. It would protect him from being charged with that. And the police knew they couldn't charge him with that in those circumstances. And they said so what the Saskatchewan court says is that you need to have a valid reason to arrest someone. If you are arresting someone for simple possession, when you can't charge them with simple possession, it's not a valid arrest. There's no real distinction. And I do kind of think if the police could do this, it really would open the door for other types of intrusive searches. Some people have said that this interpretation of the law would gut the entire purpose of the law. But then on the other hand, the government wrote this legislation the way they did. They just said charge and convict. If the government thinks that this is a problem, if the legislature thinks this is a problem, they could fix that. They could amend the legislation to make that clear instead of the courts adding in that word. So it's a really interesting case. The Supreme Court, I hope, is going to give us some clarity on this. But Joanna, what's your reaction to this as a former criminal defense lawyer?
Yeah, I mean, I think it's right. It's correct that this doesn't often come up, but the counterpoint to that is we don't want to put too much reliance on police acting with discretion. I know, for example, I don't know, I can't recall the exact instance, but there are like terrible stories about this happening in the US where people have gotten charged and even in prison for being in the crosshairs of, an overdose. And then the second thing is, I think there's a lot of evidence that even though Good Samaritan laws are on the books, a lot of people, including in Canada, don't know about them and are too scared. They're too scared to call in overdoses. And so, it doesn't even get to the justice system because people just die. So yeah, I think in this case, I don't tend to be a big fan of we should have a law to signal and make things explicit to people. But in this case, I think it's good. And I wish more people knew about it, that yes, if you call in an overdose, you're not going to be charged for also being a drug user, as is often the case.
Although maybe you could be arrested for it based on what the lower court found in this case.
Yeah. Well, we'll talk about that another time. What do you think, Josh?
Yeah, we need some clarity. Josh, what do you think?
I don't know. I'm kind of more with Saskatchewan on this, although I haven't read it, so my view could obviously change. But I think they wrote the law the way that they wrote it, and I think the text is fairly clear from the way you describe it. And like you say, they could clarify it if they wanted to, rather than have judges read something into it. In terms of how much this comes up, I'm not surprised because drugs are, whether they're decriminalized or not officially, police have essentially decriminalized them at this point, right? It's just so rare to get charged for possession. And yeah, it just reminded me about the e-scooter issue in Toronto. I know it's kind of off topic, but there was a debate this week at City Hall in Toronto. For our Western listeners, I know you love hearing about Toronto, about whether e-scooters should continue to be illegal. And anybody who goes outside in Toronto knows that there's thousands or tens of thousands of e-scooters everywhere.
They're feeding the whole city.
Time.
All the Door Dashers, all the Uber Eats guys, they're all on the little,
At least 10,000 Uber Eats guys on scooters alone, but they're illegal, and the city has decided to continue to make them illegal. And the report noted that Toronto police laid 89 scooter-related charges. So that's I don't know, one every few days when you could just walk outside and charge 10,000 people if you wanted to. So it's just funny how the police, they'll just make their own decisions about what laws ought to be or ought to be enforced. My other thoughts here are, even if, evidence is obtained in a manner that infringes people's rights, Section 24(2) of the Charter says that the evidence only needs to be excluded if, quote, having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. And I think if you look at a case like this, you could sort of go either way on that question, right? Would it bring the administration of justice into disrepute more by excluding this, letting these guys who had guns walk free just because of this, what's more or less a technicality? Or would it be a bigger problem if we're sort of gutting the Good Samaritan law as some people have framed it? So yeah, I don't know really where I stand, but there's lots of factors to consider here. And it'll be interesting to see what happens.
Should we take a break and then we come back? I'll tell you about the unsuccessful outing of Sarah Jama.
Sounds good.
Okay, so Sarah Jama, member of Provincial Parliament of Ontario, lost her case. So a little bit on the background, we did talk about this when it happened, but very quickly on October 10th, so 3 days after October 7th, Sarah Jama went on X and said she was reflecting on her role as a politician participating in the settler colonial system. She accused Israel of apartheid, chemical warfare against Gazans, and referred somewhat condoningly to quote unquote retaliation rooted in settler colonialism. So on October 18th, so 10 days after that, or a week after that, the Ontario Legislature's House Speaker, Paul Calandra, moved to censure Jama's quote unquote disreputable conduct and authorized the speaker not to recognize her until she retracted and deleted her comments and apologized in the House. And Jamma apologized and then pinned her original statement to the top of her X profile, which many perceived as defiant. Doug Ford also posted on X that she was an apologist for rape and murder. She sent a cease and desist letter to Doug Ford accusing him of libel. Then Marit Stiles, the NDP provincial leader, announced that she would eject Jamma from caucus for creating an unsafe work environment. So the vote on Jamma's censure passed. The vote count was 63 to 23. Okay, now bringing us up to May of 2024. Jamma had brought a judicial review in the Ontario Divisional Court of Paul Calandra, the Speaker of the House's censure decision. She sought to quash it and declare it to be unconstitutional. The Speaker and Attorney General responded and said that the court did not have jurisdiction to hear a challenge because of parliamentary privilege. And in the results, which was released on Monday, Divisional Court, or sorry, was it yesterday? Anyways, very recently, this week, Divisional Court held that the censure decision did indeed fall squarely within the exercise of parliamentary privilege and was therefore unreviewable even on charter grounds. And when this privilege applies, the legislature holding the privilege has the exclusive competence to adjudicate or look into an alleged breach of the charter. And the court wrote that this is just as much a part of our Constitution, the exercise of parliamentary privilege, as the charter itself. And that, by the way, was agreed upon, that if parliamentary privilege applied, that the court couldn't review the action. But what Jamma tried to argue, unsuccessfully, as well as a few interveners, was whether or not this censure decision fell within the scope of parliamentary privilege. So the first argument she made was that the censure decision was made in bad faith and reflected non-compliance with statutes and the charter. The court rejected this. They said there's no support for the proposition that the rule of law permits the courts to scrutinize the legality of conduct if it's protected by parliamentary privilege. And then they pointed out that we're not looking into the specifics of the action itself, here the censure motion. You're looking into what is the category of the action. And so here the category, everybody agreed, was control over legislative debates and proceedings in the legislature, and disciplinary authority over members of the legislature. So both of those are established categories of parliamentary privilege. And Jamma said that you need to ask whether the exercise of privilege in the circumstances was necessary. And Jamma cited a case from the Supreme Court of Canada called Chagnon. In this case, the Supreme Court held that parliamentary privilege did not prevent a labor arbitrator from adjudicating a union grievance related to the president of the National Assembly of Quebec's decision to fire 3 security guards. And they found that is not within parliamentary privilege. But control over debates and proceedings is quite different from a union grievance of individuals who are not members of parliament. So In the result, the court found that this category, debates and proceedings, as well as discipline of members, is necessary to the functioning of the legislature. External intervention would create delays and disruptions, and this would be unacceptable. And just briefly, I think we talked about this back in October when this happened. All of this sounds like a bit of a buzzkill. None of this is reviewable. There's no recourse, but it's important to keep in mind that parliamentary privilege actually came about because it was seen as a shield against improper meddling of the executive, and in particular, meddling kings and queens. King Charles I in 1629 ordered 2 members of parliament to be imprisoned for alleged seditious statements made in parliament. And the concept of parliamentary privilege evolved to protect this sphere of the legislature to essentially govern itself. So I remain sort of equivocal about this. I still think the optics of censuring, effectively silencing Jamma, who is a young Black woman, are not great. I think it's has the potential to turn her into a martyr. But I also accept that parliamentary privilege is part of our democracy. I would just say, yeah, if people are outraged by Jamma's comments, which I think they have every right to be, and it's a pattern of comments of being an apologist for terror, vote her out, right? She's democratically elected. But Parliament also has the authority to govern its own affairs. Josh, I know when we talked about this in the fall, you had like completely nerded out on the history of parliamentary privilege. Anything to comment on this? I assume you're not surprised about the outcome of the decision. I don't think anybody is.
No, this is like the least surprising decision. I mean, it's so hard to predict what judges will do because, people don't tend to go to court unless there is some live dispute, right? But this was a case where it's just so obvious that Jamma was going to lose and that her lawyer would get paid even though she was almost certain to lose. And yeah, I think you covered it really well. I think it's really important to understand that separation of powers is a huge part of our Constitution, one of the things that makes our democracy function, and people don't always realize that. And as a result of that, the courts just need to butt out until legislators actually make a decision through a statute. And at that point, that's when things become reviewable. And yeah, not hugely surprised by what happened. Christine, what do you think?
It's kind of annoying to me that this proceeded because I mean, wasn't there a possibility to have it struck for how like on summary judgment or something like that because of how obvious it seems that this was not going to succeed?
It was struck on summary judgment.
Oh, was it? Sorry.
Yeah. Sorry.
Sorry. Yeah, that's kind of what I thought it should happen. Okay, so that's good.
Yeah.
I thought I missed that part of it. I thought it proceeded. It absolutely needed to be struck because it was so obvious that it was going to lose. That's exactly the outcome that we need because the courts are backed up. There's all kinds of cases that, people are waiting months and months or longer for just motion dates, let alone full hearings. So this one, I think to everyone other than maybe Jamma, was really obvious that it was not going to succeed. And I don't know, maybe Jamma had some other reason she wanted to proceed with it, like fundraising or attention or some other cause that made her want to proceed. But that's, like our courts are not a tool for fundraising and self-promotion. And with them in the backlog state that they are, I'm really happy to hear that it was thrown out on summary. And you had a great op-ed about this a few months ago when this first came out in the Hub, Joanna. So I think you said in that op-ed that this had no chance of success. And I'm glad I didn't take you on a bet on that one. I wouldn't have taken that back because I 100% agree. Yeah. But yeah, really good outcome here.
Okay, should we move on to BLTs, bad legal takes of the week?
Sure, I'll go first. So my bad legal take goes to a person on Reddit who thinks that his neighbor's, quote, hateful signs may be criminal hate speech contrary to the criminal code. And so this Redditor writes, Nutjob neighbor across the street displaying hateful rhetoric in his window. He's been displaying a Russian flag with Putin's face superimposed on it, along with signs that say "Rootin' for Putin," and a recent edition that says "Diversity is not a strength." There's also a strange made-up flag that appears to be a Chinese flag, except replace all the stars with maple leaves. And the Supreme Court has upheld restrictions on forms of expression deemed contrary to the spirit of the Charter, more specifically, speech that incites hatred against any identifiable group where incitement is likely to lead to a breach of the peace is restricted speech that can lead to criminal charges. I'm wondering if these messages would fall under freedom of speech or hate/restricted speech. And the bad legal take here is not simply asking Redditors for to interpret the law for you, but the fact that anyone could think this is criminal hate speech to support Putin, or to say diversity is not our strength, or to imply that Canada is somehow like communist China. I think that's all obviously protected speech that can't be outlawed in Canada. And also, none of the elements of 319(1) of the Criminal Code, which is incitement to hatred, have been met. So just briefly, Section 319(1) says everyone who, by communicating statements in any public place, incites hatred against any identifiable group where such incitement is likely to lead to a breach of the peace is guilty of an offense. And first of all, there's no incitement here. Incitement means to urge on or encourage other people to hate, and I don't see any words or images on these signs that do that. Second, there's no obvious hatred here. As we've talked about before, hatred is like notoriously difficult to define. It's really subjective. So I don't personally think governments should even be allowed to ban it, but they found differently in Keekstra and Watcott. But even with those definitions, there's no way this is hatred. So in Watcott, Justice Rothstein for the majority said, hatred is, quote, to be interpreted as being restricted to those extreme manifestations of the emotion described by the words detestation and vilification. Hatred was not, according to Rothstein, an expression that ridicules, belittles, or otherwise affronts the dignity of any person or class of persons. Merely hurtful and offensive ideas are not sufficient to ground a justification for infringing on freedom of expression. And obviously, no one should be rooting for Putin, who's obviously one of the most evil dictators of the 21st century. And saying diversity is not our strength isn't very nice, maybe racist, but obviously it isn't going to come close to the most extreme manifestations of detestation or vilification. There's also the identifiable group question. What group is identified here? And maybe you could argue that saying diversity is not our strength is targeting all non-whites or something like that, but these flags don't really say that. And obviously the Rootin' for Putin sign is offensive to Ukrainians, but it's not identifying them as a group. And I don't even think this necessarily counts as a public place, although that's arguable. So that's why it's my bad legal take.
But I did, Josh, I did click through to the Reddit post, and the comments do pass the vibe check. One says, put up a Ukrainian flag that says Zelensky, my main Mansky written under it. And then somebody said, fly a trans flag, a Palestinian flag, and also just to F with him, a Confederate flag.
Oh yeah. I think
Good
that's what you got to do. That's exactly what you got to do. I have a friend who's going to put up he wants to put up the Pride Progress flag, but also an F Trudeau flag beside it, just to screw with his neighbors, not for any other reason. So yeah, that's
Well,
probably
ask
the best
Justice
strategy
Alito's
here.
wife about that, about screwing with neighbors and putting up flags. It cannot end well.
For sure, but we don't need to get into that. Christine, what's your bad legal take?
So my bad legal take goes to Senator Patrick Brazeau by way of media shock jock personality Dean Blundell. So Senator Brazeau has proposed Senate Bill S-254 that would mandate labels on alcoholic drinks that show a link between alcohol consumption and 7 types of cancer. Now, my understanding is that there actually is a link between alcohol and cancer, but that it is not quite an apples to apples comparison to the link that exists between cigarettes and cancer. So there was a study by University Hospital Southampton, Bangor University, and University of Southampton. And they found that the risk of cancer from drinking 1 bottle of wine a week was equivalent to smoking 10 cigarettes a week for women and 5 cigarettes for men. But of course, smokers tend to smoke a lot more than 10 cigarettes a week if you are a smoker. And smoking does have a very strong link to cancer. About 20% of cancers and 30% of cancer deaths in the US are caused by smoking. About 80% of lung cancers and 80% of lung cancer deaths are because of smoking. And lung cancer is the leading cause of cancer death in people in the United States. So it's a pretty strong link between cigarettes and cancer. It does not seem to be quite as strong between alcohol and cancer. Look, I'm not saying that alcohol is risk-free, or I'm not even denying that there seems to be some relationship between cancer and alcohol. But just frankly, many activities that we engage in on a daily basis increase cancer risk. Barbecue meat, smoked meat, processed foods, sun exposure, all of these things increase cancer risk. But we don't label all things because they have a cancer risk. It has to meet some threshold where that risk is much higher. I think that a bill proposing putting this risk on a label for wine or alcohol is just not a good idea. Dean Blundell, so he thinks that it is a good idea. He said the picture on the label should show a person experiencing liver failure, which, by the way, I looked up. It actually looks terrible. It would be a terrifying image on a label. When you have liver failure, your stomach can get extremely distended, and your eyes and skin can turn this really ghastly shade of yellow color. I do think it's a good idea to talk about the risks associated with alcohol consumption. And I also think that Patrick Brazeau comes from a sincere place. He is a recovering addict who was ordered to rehab by the court. He has seen firsthand the destructive toll that alcohol can take on people's lives. It took a toll on his own life. But I think that the government putting labels on alcohol is not the appropriate solution. It might not even pass constitutional scrutiny, although we'd have to look more at the evidence to see how Section 1 might, come into play there. I think that the risk threshold, the risk would just have to be quite high the way it is with cigarettes. I think with cigarettes, I don't know how much I buy that it's the labels on cigarettes that have reduced smoking rates. I think that the social stigma around smoking has shifted really dramatically. I think if you poll single people, like one of the number one red flags single people will list of like a reason they will not date someone is because if they are a smoker. There is a tremendous social stigma to smoking. There has been a lot of public education around smoking. And there's just really widespread knowledge about the risks of cigarettes that I don't think is all attributable to the labels. I also think if we call every single thing in life dangerous and risky, people cease to believe warnings. Like if we say alcohol is as risky as cigarettes when it is not, people will cease to believe the warnings on alcohol labels. So there's this sort of notorious warning label on every single product basically coming out of California or sold in California. It's a label called California Prop 65. And it says, pretty much everything from furniture I might order on Wayfair to, cushions and things. It says this product can cause reproductive harm. And it's at the level where it's on so many things. People just they just ignore it. They don't believe it. And I think a better solution is public education around alcohol consumption, the risks associated with binge drinking, and negative health and social consequences of unhealthy alcohol consumption. That said, I of course enjoy wine. So another reason I don't want this on the label. I don't want to look at these horrible images that Dean Blundell wants posted on the wine labels. But That is my bad legal take, even though I do acknowledge that Senator Brazeau is coming from a sincere and good-hearted place. Joanna, your BLT.
It's the boy who cried wolf principle, I guess. Yeah,
Yeah.
of safety labeling. Okay, my bad legal take of the week goes to Jesse Brown, who in general, I think has had very good takes for the last 6 months. Much to the chagrin of the staff of Canada Land, he has been relentless in calling out and fearless in calling out anti-Semitism. But here I disagree with him. So he quote tweeted Toronto Mayor Olivia Chow responding to the shots fired, shooting. I don't think we know exactly the details. There were shots fired at 5 a.m. at Beis Chaya Elementary School, which is a Jewish religious girls' school. And he said just 2 days ago, so she's decrying the despicable anti-Semitic act. And Jesse says, just 2 days ago, Mayor Chow voted against creating safety zones around faith-based schools. She argued that existing laws and tools are sufficient and suggested safety zones may violate rights to freedom of expression. Okay, so first of all, do you think that the existing law doesn't already criminalize showing up at a school at 5 in the morning and firing shots? That's like covered by multiple laws, trespass, criminal law, wielding a gun. Second of all, if there was a so-called buffer zone or bubble or safety bubble around this school, do you think these two sketchy individuals who saw the need to show up at 5 in the morning would have been deterred by it? I don't think so. I think in this case, she's right. Existing laws are sufficient. Perhaps the school needs better security. I guess security has been beefed up, but under no circumstances and in no legal universe is it lawful to show up and shoot bullets at a school. So the solution here is certainly much more complex and deeper rooted than just imposing a bubble zone. Sorry, Jesse.
All right, that's the end of the show. So as usual, we hope you'll rate us, review us, and subscribe. And just a reminder, you can support our work by subscribing to the CCF's YouTube channel, to the Not Reserving Judgment YouTube channel, or by visiting our website and signing up for our Freedom Update newsletter from our colleague Russ. The Canadian Constitution Foundation is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thank you.